The Ohaneze Ndigbo worldwide has condemned the bill in the Senate, seeking to permanently elevate the Ooni of Ife and the Sultan of Sokoto as the exclusive co-chairman of the Traditional Rulers Council. The group said the move will be at the expense of Ife's traditional rulers from other ethnic nationalities and geopolitical divides. The National Publicity Secretary of Ohaneze Ndigbo worldwide, Dr. Ezechi Shuku, said this in a statement. Also, the Ijaw National Congress has condemned the bill, saying that the move will be at the expense of other apex traditional rulers from other ethnic nationalities and the geopolitical divides in the country. Joining us now on this show to discuss this proposed bill is Michael Aondoakaa, SAN, former Attorney General and Minister of Justice. He will also reflect on why 76 oil wells were seeded from Cross River to Akwa Ibom and clarify issues surrounding the littoral status of Cross River State. Good morning, Mike Aondoakaa, SAN. Good to see you, sir.
Good morning.
Morning, sir. Thank you.
Good morning.
Thank you for joining us. Well, let's deal with the foundation first before we go to the politics, because about who heads, who does not head the proposed council is political. In the 1960 and 1963 constitutions, provision was made for traditional rulers to be part of governance. And, we saw some of them from the north and from the southwest are playing very prominent roles in the governance process as persons, as traditional rulers closest to the grassroots. Now, 1979, 1999 constitutions, they were marginalized. They became appointees of state governments and local governments and all of that. Now, under the Bola Ahmed Tinubu administration, we have a bill before the National Assembly to reintegrate them into the governance process. But a lot has changed since 1963. This is a present generation of traditional rulers. They are not of the same type that we had in the First Republic. Do you think that there is value in involving traditional rulers in the governance process as is being proposed?
Well, I think there's value, but how it is being proposed is the issue that we can contest. You're a lawyer, will contest the legality of it. There's value, but in the manner it is coming, I don't think it will meet the legal expectations.
Well, what do you object to in terms of the manner? The chairmanship?
Well, if you see, the classical law is that when you pick a piece of legislation, you read it harmoniously in relation to other provisions in the legislation. Let's take offices created by the Constitution. You start from the president. There's nowhere it is fixed, so people should bring president, so people should bring vice president. If you go to even the Senate president, you say elect among the senators. The same thing with House of Reps, and even around the states. So that is the direction. If you are trying to introduce traditional rulers again into our constitution, the issue of offices will follow the same pattern the other offices have been created. And therefore, if you bring that into the constitution, and now you are introducing a pattern that does not fit into the other offices created, you will be creating a kind of legislation that will be assault with other provisions of the Constitution. Office of President is not specified that it should come from the north and this should come from the south. Vice President, the same thing. Senate President among the senators, Speaker among the something. So it looks strange, but I really don't know whether it's a proposed constitutional amendment or a private member be sponsored. If it is just a private member be sponsored, clearly is an unconstitutional exercise because the federal government has no power to legislate on traditional institutions. But if it's a constitutional amendment, then you look at it from the areas appointed to you, the provisions will be assured, will not fit into the other offices created by the Constitution. And therefore, again, the second aspect is that you don't create a law when you know at the end of the day it will be defeated. If you introduce traditional rulers and create the office of chairman, co-chairman in the manner being proposed in that bill, I wonder whether the issue of two-thirds of the state's concurrence will be achieved. Therefore, it may be kind of wasteful exercise, waste of resources, waste of time, because you already heard Indigbo opposing that it's about 5 states. You know 5 states in the states. In the South, I'm not sure whether you can get anything around the North Central region. You may not. You may also not get anything around even Northeast, because the Shehu of Borno may say no. That means Borno may decide not to be part of it. The Lamido of Adamawa may say no. So you don't just create an academic exercise. This to me, whether it's going to second reading, is purely an academic exercise. It cannot fly in any way. If it's coming as a private legislation, not a constitutional amendment, it's completely a nullity because they don't have power. If it's a constitutional amendment, it's also not going to fly because it's a waste of time. You cannot get the two-thirds of the states.
Okay.
So the debate of it, to me, it does not make sense to me to even talk about it because you don't waste energy, Ruben, on things that may not, it's academic.
Oh, okay. Well, having said that, we might take the position that it's academic, beyond the politics of hierarchy, which in themselves are very, shall I say, are very challenging, given the diversity that we have. There's some that will still say that the clamor to include traditional rulers in the Constitution is still a noble one, that maybe this Traditional Rulers Council bill in its current format might be the wrong way to go about it, but that traditional rulers deserve to be acknowledged in one capacity or the other in the Constitution. What are your thoughts on that?
I said I totally agree with that. They have an important role, that the people with the grassroots, and some sort of legislation or constitutional amendment should be done to include them. That one I have already, the General Council said is acceptable. That yes, they need to, because they are closer to the people. They are like, you see religious bodies, they don't have any coercive powers, but when they say people obey them than people with coercive powers. So the traditional rulers, people in their communities, the villages, the community leaders, they obey them even more than our regular security outfit. Therefore, with such contribution they have, it is important to create a forum within which they can contribute to national development, national security, and otherwise in the Constitution. That one, the general framework is notable, but it is the unfortunate introduction of the clause that can create a problem. Maybe they have to revisit it. But at the same time, I have not gotten a clear picture whether it's a constitutional amendment or it's a private member bill initiated as a bill of the National Assembly. If it's a bill of the National Assembly, I'm afraid to tell you that the issue of traditional rights is on the residual list. So I don't see how National Assembly has the power. It's not on the concurrent list. It's not on the exclusive list. But if it's a constitutional amendment, then that is okay. But if it is a private member bill brought by a member from Plateau, I don't think how that can work, except he's bringing it as a commencement of a constitutional amendment.
Okay. Oh, well, the other issue that I raised, you know, in the First Republic, some of the traditional rulers get embroiled in the politics of the period. Sade Soji Aderemi, the Oni of Ife at the time, was the governor of the Western region. Now, much later, the Olowo of Owo, Sir Olateru Olagbegi, also got involved in that politics between the AG Action Group and the NCNC, leading to eventually, in the long run, to his deposition, although he was later reinstated in the throne. Even if this goes through, I get the argument that it will not work, whether it's a private member's bill or it's a constitutional amendment. What the persons pushing the bill are asking for is the alteration of Section 220. But shouldn't we insulate traditional rulers from politics? Because even if at that time we had traditional rulers getting involved in politics, it could be worse now.
I think I'm afraid I have to agree with you totally. The situation here in Nigeria now is that everything is politicized. It's politicized to an extent that the community looks onto the traditional rulers as neutral. Now, the difficulties we have in individual states is that even if you make an alteration, the law relating to their appointment still is the state law. And the governments of the day in that state, the political party that governs at that time, have control over their appointment and have control over their removal. You can see what is happening in Kano. These are the potential potential dangers that are manifesting already. You saw what have two emirs already in Kano. And it's like a game. When that government comes in, it creates its own emirate. The other one comes, it dissolves the emirate. And that is the situation we have. Because traditional rulers, except you are going to amend and take up completely traditional rulers and place them on the exclusive list or concurrent list. But then how would you do that? How would you place the traditional on a concurrent? You don't know them. They are called traditional rulers. They are elected by their communities, by the elders, and recognized. So how will even federal government in the long run say, I would do a general law relating to regulation of appointment and the removal? So if that is the potential danger, I also believe that the situation will be more complex now than even before. Even with now, first they are professed to be apolitical. But it's difficult to be apolitical in a situation where the traditional rulers and their removal will be closely guided by the party that is in control of the state. In fact, you will create a constitutional amendment which is desirable, but then you will have no control over the appointment and removal of the traditional rulers by the National Assembly. And that is some of the potential dangers I see in the legislation. It has to be studied very well. Anybody who is, it's not something somebody just wake up today and say, I want to do an alteration. It has to be studied very well. If at all, weigh the merit and demerits. If the merits, as of now, it's a 50-50 issue. The merits and demerits are like 50-50. And I cannot say I associate or I dissociate at this stage. Okay. The dangers are more glaring than the advantage.
Okay. Well, speaking of studying things very well, we seem to be reaching a stalemate between Cross River State Government and Akwa Ibom State Government concerning these 76 oil wells and the maritime borders and so forth. It seems to be something that's straightforward in black and white, but it has caused a renewed clamor, especially from Cross River State, who are demanding justice. What's your take on the literal borders around Cross River State, the literal status, rather, of Cross River?
Well, the situation played out during our time, and I'm not actually indicting the people of Cross River, but I'm trying to put the records straight. You know, the vice president then, President Jonathan, who became the president, is naturally in the law, a boundary commission, he's the chairman. And then next is the Attorney General. And we have a DG. At that time, it was Mr. Diggy. And we wanted a fair play in both states presenting their position. Because when we handed over Bakassi, which I was the one who handed over as on behalf of the federal government, the oil ways that were in the Bakassi, Cross River was hemmed out. So what was left was the oil way that were on the land. So from the report I got from Diggy, we dispatched the boundary commission's officers, led by DG, to go to the contesting parties. And they have a look at their case. And they were arrived in Calabar. I think the governor was not around. And our hear from them separately, hear from Akwa Ibom separately, and after that, call all the parties together. I think for like 5 days, they were in Calabar. No official Cross River came there. And the time we gave them to listen to Cross River passed. They also went to Akwa Ibom. They were welcome and they made their presentation. It was like you file a matter and there's no defense. But after that, when the report was submitted and we took action, the governor came, Liyel Imoke, wanted to reopen the matter. I think the vice president, then now President Jonathan, he was sympathetic. I was sympathetic, but majority of the members felt that they waived their rights at that time because they had every opportunity. Nobody came to the boundary commission throughout the 5 days they were in Cross River. It was a very unfortunate situation. I've never seen a situation like that where officials of the state will be so nonchalant on such sensitive issues. So I don't want to go further more because I was privileged to be a player and I wouldn't want to disclose government secrets to a certain level. But certainly, such a sensitive thing, and you had a letter coming from an office of the vice president, chairman of the boundary commission, introducing these parties are coming simply because your governor is not around. Nobody could even receive them. They have to find their ways, stay, wait, and nobody could arrange where the people will sit, and nobody could appear before them. And the time for their presentation was 5 days. They left to Akwa Ibom, where they were welcomed and they did their presentation. And when we came back to sit on the matter, the report was, we had no contest on the Cross River's claims, made our recommendation to the president. And that's all it was.
But sir, it seems to me...
when the governor came back...
But sir, it seems to me that the major question now...
What?
26 years after, it seems to me that the major question to resolve is whether or not Cross River State has any case, to the extent that the ICJ in the Bakassi matter had decided that Cross River State does not have a seaward territory, that it is not a littoral state, and that the 200 meters isobath, with the effect of the ICJ ruling, now belongs to Akwa Ibom, to which that 200 meter seaward territory is contiguous. Cross River went to the Supreme Court twice. Twice, the Supreme Court of Nigeria also ruled in favor of Akwa Ibom. And then Akwa Ibom, maybe as a result of the intervention that you just described, now offered Cross River State 250 million ex gratia monthly. So why is it that 26 years later, the same Cross River is bringing up the matter again? What do you think could be the motive? Do they have a case?
These are the challenges that were present that time, and these were the issues Akwa Ibom presented with Supreme Court decisions back in them. You see, these are the issues. I think there were like 2 oil wells that were remaining on the land, which was in contest, which could have still made Cross River State an oil-producing state. But I said, Ruben, honestly, I don't think if you sleep over your rights, you can then look at status or limitation. For 26 years, you just come back and say you want to reopen the matter. I wonder whether that is founded in law or even iniquity. I don't look at it founded in law or iniquity.
Yeah.
I don't think so.
So you're saying that even if they can prove that there was... Okay, sorry, go ahead.
Vigorously during the government of President Yaradua. They could have done this during the government of President Jonathan himself, who was then also, as vice president, was chairman of the Boundary Commission. Then they did not. They did not.
Okay, but
the issue of the areas that are covered by the Supreme Court, if nobody accepts legislation, you can't just overlook the judgment of the Supreme Court, and that those areas is not even a contestable issue. I think the focus would have been the 2 or 3 oil ways that were on the boundary within the territorial boundary, not the sea issue. I think that is the target at that time, to tell Akwa Ibom, please, that was the thinking of everybody. That, oh, look, you have a fair share with so you can allow your brothers, the others, let's do an adjustment that we accommodate them to remain in the oil producing state. But they didn't show up.
Well, but
at that time, they didn't show up.
Before we go, I mean, I get the point you made about the statute of limitation. Is the ICJ ruling also covered by the statute of limitation? Is there any hope that Nigeria can reopen the Bakassi case?
Enforced.
Okay.
The Bakassi has been opened, the last stretch of Bakassi implementation, because I was the joint chairman of the Green 3 Agreement. I was the leader, and then there was the Attorney General came around that time. So we have completely implemented the Green 3 Agreement, which was signed, was a vehicle for implementation of the ICJ, the judgment. So I don't see how, if judgment has been completely enforced, the last stretch of the judgment was the handover of Bakassi. So I don't see where anybody can come out. Can you don't reopen a judgment has been enforced completely and the issue buried?
Well, thank you very much.
Things happen. Law springs up every day, so I wouldn't know. But this state party, the Green 3 Agreement, was signed and witnessed by the 5 superpowers. And we had meetings in Switzerland severally on the implementation of the Green 3 Agreement, starting from Bruno down, which some villages were considered to Nigeria, down to the issue of Bakassi, down to the coastal area. We have completely implemented the Green 3 Agreement and completely handed over the last stretch, which was Bakassi. And that closed the chapter of the judgment. So where is somebody coming again that I want to reopen the judgment that has been implemented?
But technically, Cross River
mind you, at that time,
no
we
case.
had a lot of contention, and I stood my ground because we had already started the implementation under the Green Agreement from the northern part of Nigeria, and Nigeria accepted the villages that were giving. And when we came to Bakassi, then people came in and said, we cannot implement the judgment was unfair, and this and that. And I said, look, we're in the community of nations. If we never wanted to obey the judgment, we couldn't have been a party to the Green Tree Agreement, we couldn't have accepted the villages in the implementation of the Green Tree that were considered from Cameroon to Nigeria. We accepted all this. And when you got to Pakapa, we said we will no longer go. And I felt it was more honorable and desirable, Nigeria being a major power within the African state, to live by example and accept the judgment completely. And that's what we did.
Well, thank you very much.
Thank you very much.
Mr. Michael Aondoakaa, SA.